All right, so this lecture is a continuation of substantive due process. Now, in the last one, we traced how the Supreme Court built an enumerated right to privacy case by case out of the Due Process Clause. In this one, we're going to follow that doctrine to its most contested applications, and that's the right to end a pregnancy, the right to refuse medical treatment, and the question of whether a terminally ill patient has a right to end their own life with a physician's help. Okay, now I want to say a word about how we're going to handle today's material because it matters. Abortion and end of life autonomy are two of the most politically and morally contested subjects in American law. Now, our job is not to resolve those moral debates. That's not what a constitutional law class does. And it's genuinely not my place to tell you what to believe. Okay, our job is to understand the legal doctrine with precision, like what the court actually held, why it held that, how the reasoning changed over time, and what arguments exist on multiple sides of the doctrinal, questions. Now, hopefully, you're going to leave today being able to explain Roe and Casey and Dobbs very accurately to somebody else. And that's regardless of your own views on abortion policy. And that skill, that precise, doctrinal fluency that's independent of personal opinion is exactly what distinguishes, a good legal understanding of this area from a purely political one. Okay, so as you see, it says how the Supreme Court reconsidered liberty. So that word, reconsidered, is doing the real work today, okay? So today's doctrine, it's not a straight line. It's going to move, it narrows, it gets overruled, and tracking exactly how and why the court's approach shifted, across 5 decades is central to today's task, okay? Now, I do want to say, before we start, again, I want to note, today we're going to talk about Roe, Casey, and Dobbs, along with the right to die cases. So if anything we discuss, feels personally difficult, that's a completely normal reaction to this material. And you are welcome to pause, skip ahead, whatever it is that you need to do. This kind of thing isn't, required for every single class, but I just did want to put it out there because this is a topic that is sensitive. And I figure, may as well just let it be known that I understand, and I do want you to be as comfortable as possible when engaging seriously, with the doctrine. All right, so the module objectives are listed clearly. We are going to explain abortion jurisprudence. We're going to analyze Roe, Casey, and Dobbs, define the undue burden test, explain medical autonomy, and analyze the right to die cases. Now, notice the kind of architecture of today's lecture, because we're going to move through two connected, doctrinal families. The first is the abortion jurisprudence, which is the Roe, Casey, Dobbs cases. Those occupy roughly, the first portion of our lecture. The second is the medical autonomy, and that is the right to die cases. So we're talking the Cruzan, we're talking Schiavo, Glucksberg, and Vaco. And that's going to take up the rest of our time. Now, both families share the same root, okay? And that is the the unenumerated liberty interest under the Due Process Clause. And it's the same soil that we were, playing in our last lecture. So by the end of this one, you should be able to do a couple of very concrete things. You should be able to state the holding and the doctrine significance of each major case that we cover. You should be able to explain how the legal standard for abortion regulation changed from Roe's first trimester framework to Casey's undue burden test, and then how Dobbs eliminated the federal constitutional right altogether. You should be able to distinguish the right to refuse treatment from a right to assisted suicide, and then explain why the court has treated those two questions so differently. Okay. And last but not least, you should also be able to articulate the competing judicial philosophies of originalism and living constitutionalism that explain why the court's approach to these unenumerated rights have shifted so dramatically between 1973 and 2022. Okay. Now, before we go anywhere new, let's kind of re-ground ourselves into what we already established last week, okay? This slide clearly says, how did we get here? Well, the last lecture built a right to privacy case by case, not from any single clause of the Constitution that says the word privacy, but from a doctrine that the court developed gradually, reading the Due Process Clause of the 14th Amendment as protecting more than just procedural fairness, okay? It protects certain substantive liberties as well, hence the term substantive due process. All right, that is the same, you know, doctrine that is driving everything that we discussed today. All right, and today's question is simply how far does personal autonomy extend under that same doctrine? Okay, now all right, I had to shift my PowerPoint around. So I do want to kind of flag something that's important about method before we go digging into these new cases. So the doctrine that we're about to trace today, privacy, then abortion, then medical autonomy, is kind of a textbook example of how common law style constitutional reasoning works. The court doesn't announce a fully formed right to bodily autonomy in one case. It is going to build it incrementally, okay? A case about contraception here, a case about education there, each one continuing to kind of widen that zone of protected liberty just a little bit further until eventually a case arrives that asks the court to apply that accumulated doctrine to a genuinely new and much more contested question. All right, so abortion is exactly that kind of case. All right, so keep watching for that incremental kind of case by case pattern as we move through the material because it's going to explain both how Roe was decided in 1973 and just as importantly, why Dobbs was able to say um, in 2022 that the incremental logic had gone too far. Let me remind you, you don't have to agree with it to understand it. All right, that's all. Now, as you can see, we have our building blocks. We have 5 cases spanning nearly 50 years that each widen the zone of autonomy the court would eventually draw on in Roe. So I want to walk through all 5 very briefly, simply because we already covered them all, but it's because Roe doesn't really make sense without them. First, we have Meyer versus Nebraska, 1923. So the court struck down a state law that was banning instruction in foreign languages, holding that the parents have a liberty interest in directing the raising and educating of their children. All right, notice this has nothing at all to do with reproduction. It is strictly parental authority, okay? But it establishes something crucial, and that is that due process, or the due process clause rather, protects certain family and child rearing decisions from government interference, even though nothing in the Constitution's text mentions education or parenting. Then we have Pierce versus the Society of Sisters, which is from 1925. That case struck down a law requiring children to attend public school, protecting the right to choose private education. Again, no mention of reproduction, no privacy in the modern sense, but another brick in that same wall. Okay? Family decision making is constitutionally protected liberty. All right? Third is Skinner versus Oklahoma, 1942. This one gets much closer to our topic today. Oklahoma had a law allowing forced sterilization of certain repeat criminal offenders. The court struck it down, recognizing procreation as a fundamental right, calling it one of the basic civil rights of man. All right. This is one of the first of our 5 cases to touch on reproduction directly. And it's genuinely striking, you know, that it kind of came from a forced sterilization case rather than anything resembling reproductive choice as we would frame it, you know, today. Now, now, just some food for thought. Why might Skinner, a case about the government facing or forcing someone rather, um, not to reproduce, actually support a later case about the government preventing someone from choosing not to reproduce? What's that common thread? The reality is that both involve the government controlling an individual's reproductive decision making. The direction of the compulsion differs, but the underlying liberty interest, which is freedom from the government control over reproduction, is still structurally the same. Now, fourth up, we have Griswold. And it's Griswold versus Connecticut, and it's from 1965. And this is the case that most con law students already know at least a little something about. Connecticut banned the use of contraceptives, even by married couples, and the court struck the law down, finding a right to marital privacy, famously locating it in the penumbras and the emanations of several Bill of Rights guarantees, working together to create zones of privacy the government couldn't invade. All right, so Griswold is the case that gives us the actual word privacy as a constitutional term, of kind of art in this line of doctrine. Fifth is Eisenstadt versus Baird, and that's from 1972, and this is just 1 year before Roe. Okay, the court extended Griswold's logic from married couples to unmarried individuals, holding that the right to make reproductive decisions belongs to the individual, not solely to the marital relationship. So the court's language here is definitely worth remembering, near verbatim, because it becomes central to Roe's reasoning the very next year. And that is, if the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters that are so fundamentally affecting a person as the decision whether or not to bear a child or beget a child, actually. Okay, so keep that in mind. Now, by the time we reach 1973, the court already has 50 years of precedent establishing that the Due Process Clause protects family, procreation, marital and individual decision making from unwarranted governmental intrusion. Okay, so Roe doesn't invent a right from nothing. It's the next incremental step in a line the court had already been, walking for half a century. So, whether that next step is a legitimate extension of existing doctrine or a step too far beyond, what those earlier cases had supported, is exactly the disagreement that runs underneath Roe, Casey, and eventually Dobbs. Now, keep that tension in mind because we are going to return to it when we reach, the interpretive debate slide. So before we get to Roe itself, this introduces a concept that we'll need for both halves of today's lecture, and that is medical autonomy. It's built from three overlapping ideas. That's bodily integrity, privacy, and liberty interest. So bodily integrity is the most intuitive of the three. So that's control over one's own body, free from unwanted, government compelled intrusion. So privacy here is the same, doctrinal zone that we trace through Meyer and Griswold and Eisenstadt, the same family and reproductive privacy cases. They simply extended to medical decision making more broadly. Okay. And liberty interest refers to the broader category of protected personal decision making that the Due Process Clause covers. And it's an umbrella term that both privacy and bodily integrity ultimately kind of sit underneath. Now, just kind of ponder that if bodily integrity, privacy, and liberty interests all kind of overlap this very heavily, why do you think the Supreme Court uses three separate terms instead of just picking one? All right, and I know that might seem like a weird question, but think about it. Each term has a slightly different, you know, doctrinal weight and history. Okay. So lawyers often will argue using whichever framing is the strongest for their specific cases. And the courts will sometimes blend all three into a single opinion without any kind of, distinguishing of them. But the ultimate thing here is that I want you to hold on to this three-part concept as a genuine like through line, okay, for the rest of this lecture. Abortion doctrine is fundamentally a medical autonomy question. So it's control over a decision involving one's own body and reproductive future. The right to die cases in the second half is also fundamentally medical autonomy questions. Okay, control over decisions involving one's own body and mortality. Same underlying concept that, but applied to two very different moments in the human lifespan. One is at the beginning and one potentially at its end. So let's set the historical stage before we read Roe itself, okay? Now, this slide right here gives us three facts about the legal landscape leading up to 1973. We have most states criminalized abortion. There was a growing reform movement, and that movement was driven substantially by medical and feminist advocacy. Okay, so it's worth understanding why abortion had become criminalized across most states in the first place, historically speaking. All right, so many of these criminal statutes dated back to the 19th century, and the medical justifications offered at the time, which were concerns about the safety of the procedure itself, given, the state of medicine in that era, had largely been overtaken by advances in medical safety by the 20th century. So by the 1960s, a reform movement was gaining a real momentum, arguing that criminal abortion laws were increasingly, out of step both with modern medical practice and with the constitutional privacy doctrine the court had just been building in Griswold and its predecessors. All right, so this reform movement, it had two overlapping strands that are worth, kind of separating out, since they brought somewhat different arguments to the table. So, medical advocacy emphasized patient safety, the reality that abortion would occur regardless of legality, all right, and that criminalization pushed the procedure into unsafe, unregulated circumstances. So, feminist advocacy emphasized autonomy and equality, the argument that control over reproductive decisions was inseparable from women's full and equal participation in social and economic life. Okay, so both threads converge in this case that we're about to dig into, and you'll see the traces of both arguments echoed in different parts of Justice Blackmun's opinion. All right, so I'm going to use the same kind of case brief structure that we've been using, which is like the facts, issue, holding, and significance. So Jane Roe, which was a pseudonym for Norma McCorvey, was the plaintiff, and she challenged a Texas law that banned abortion except to save the mother's life. Okay, so Sarah Weddington, she served as the lead counsel arguing for Roe. Now, Harry Blackmun gave the majority opinion, okay? So the issue was, does the Constitution protect the decision to end a pregnancy? Now, notice how this is framed. Not is abortion good policy, but specifically whether the Constitution protects the decision. All right, that's the legal question a court actually answers. All right, the policy question is a separate matter in our system to legislatures in the first instance, subject to whatever constitutional limits actually apply. All right. The holding was yes. So a right of privacy under the 14th Amendment extends to the abortion decision, but that right is not absolute. It's balanced against the state's interest, and that balance shifts as pregnancy progresses. Okay, so that's worth kind of sitting with for a moment because it's a genuinely nuanced holding. It and it is kind of it's often flattened in popular discussion into something more simple than what the court actually said. Roe didn't hold that abortion could never be regulated. It held that the decision was constitutionally protected. subject to a specific balancing structure that we're going to talk about actually on the next slide. But the significance here was that Roe established a constitutional right to abortion and introduced what's called the trimester framework. All right, so it was a structure for determining how much the state's regulatory interest could weigh against an individual's privacy rights, depending on how far the pregnancy had actually progressed. So think about this based on what we've just covered about like Griswold and Eisenstadt. Can you predict like what specific line from Eisenstadt that Justice Blackmun likely built on most directly? And I'll just go ahead and kind of spell it out here for you. It's the right of the individual, married or single, to be free from unwarranted governmental intrusion, okay, into the matters so fundamentally affecting a person as the decision whether to bear or beget a child. So Roe extends that same individual decision-making autonomy specifically to the decision to end and not just begin a pregnancy. Okay, so let's be precise now about where in the Constitution this right is located, because the majority grounded the privacy right in the liberty protected by the Due Process Clause of the 14th Amendment, not notably in the Ninth Amendment's reference to the unenumerated rights retained by the people, though there are some earlier privacy cases that had kind of gestured toward the Ninth Amendment as kind of like an alternative textual hook, but Roe was settled very precisely on the 14th Amendment's Due Process Clause as the primary doctrinal home for the right, which is exactly why this entire unit of material sits under this heading, substantive due process, okay? Now, I have one last framing point before I move into the trimester framework itself, and that is that Roe's central innovation wasn't simply recognizing a right. It was recognizing a right that had to be balanced against this, countervailing governmental interest that itself grows stronger over time. Okay, so the structure, that structure feature right there, it was a right that weakens against government interest as the circumstances change. And it's genuinely unusual in constitutional doctrine. And it's exactly the feature that Casey would later restructure and that Dobbs would ultimately eliminate. Now let's talk about this, the actual mechanics of Roe's balancing structure. You have permissible state regulation that's increased as pregnancy progresses towards viability, and it's organized around 3 trimesters of pregnancy. So in the first trimester, which was roughly weeks 1 through 13, the state could not regulate the abortion decision at all. Okay, the decision belonged to the woman and her physician, full stop. Okay, with essentially no room for state interference at all at that stage. Now, in the second trimester, which was roughly weeks 14 through 27, the state's interest in protecting maternal health became strong enough to permit regulation, but only regulation reasonably related to maternal health. So, not regulation that's aimed at prohibiting the procedure itself. All right, so the third trimester, you have roughly weeks 28 through 40. And the state's interest in potential life became strong enough so that the state could regulate or even stop abortion entirely, except where necessary to preserve the life or health of the mother. An exception that the court held was constitutionally required no matter how the state chose to regulate at that stage. Okay? Now, running through all of this viability, all right, and is up until like the point of 24 weeks right there. Um, the point at which the fetus could potentially survive outside of the womb, the viability functions as kind of this doctrinal hinge of Roe's entire structure. So it's the moment the state's interest in potential life is treated as becoming compelling enough to justify the most serious regulatory measures. Now ask yourself, like, why do you think the court chose viability specifically as the key line rather than, say, conception or a fixed number of weeks that were unrelated to fetal development specifically? Okay. Guy, let me say this. Viability. It was framed as the point where the fetus could theoretically exist independent of the mother, right? Which the court treated as meaningful change in the balance between the competing interests. All right, so just think about that. The choice itself was heavily criticized and debated, but nonetheless, we're moving on. One more thing that I do want to kind of point out is in this particular framework that becomes later is the trimester structure ties permissible regulation to um, a very rigid calendar-based schedule that is largely independent of what specific regulation is actually at issue. So the rigidity is precisely kind of one of those things that critics on the court itself, including some justices who supported the underlying right to choose, found administratively awkward and, doctrinally hard to defend as medical technology around viability continued to advance. So that criticism is exactly what kind of opens the door to Casey's restructuring, which we'll talk about next. I forgot there's a slide in between, so let me just back up here. So let's talk about these interests that Roe's balancing test actually weighs against each other. So we have the maternal health, the potential life, and viability. So, maternal health is the state's interest in protecting the woman herself throughout pregnancy. Okay, an interest the court recognized as growing more legitimate to regulate around as the pregnancy and the medical risk associated with the procedure itself also progressed. All right, potential life is the state's interest in the developing fetus, just explicitly described by the court as growing stronger as pregnancy progresses, rather than or rather than existing at some like fixed constant weight from like conception onward. Okay, and this is a crucial structural choice because Roe does not treat the state's interest in potential life is either absent or absolute at any single point. It treats the interest as increasing along a continuum. All right. Viability, as we just discussed, this functions as the key regulatory line. It's the survivability outside of the womb, the point where the potential life interest was treated by the court as becoming compelling enough to justify serious state regulation. Now, think about this. Can a legal test built around three factors that are weighted differently, um, you know, depending on a specific point in a 9-month timeline, like ever really be simple to apply consistently, case by case, in lower courts, across the country? This is where we start having conflicting opinions, regarding this potential difficulty. But it's this exact debate, that this critique that motivates Casey's later restructuring into a single undue burden standard rather than a three-factor balancing test tied to trimester boundaries. Okay, so hopefully you can see kind of how we're progressing. But the reality here is that Roe recognized a genuine constitutional right, but built it on this intricate, medically anchored balancing structure. And that structural complexity, more than the underlying right itself, is exactly what state legislatures spent the next 2 decades testing, probing, challenging, and eventually producing the case that is Planned Parenthood versus Casey. And that case, 19 years later, would reshape, not eliminate, the right that Roe recognized. So now we set the stage for our second major case, which is Planned Parenthood versus Casey. Um, we have two main facts that we're going to focus on, which is Pennsylvania's 1989 abortion restrictions and then the mounting pressure to overturn Roe entirely. So between 1973 and 1992, the composition of the Supreme Court changed substantially, and so did the more broad political and legal environment that was around Roe. Several justices appointed during this period had expressed skepticism about Roe's reasoning. And a number of states, including Pennsylvania, had passed increasingly specific abortion regulations that were designed, at least in part, to test how much of Roe's protection actually remained durable and to give the court a way to reconsider the decision entirely if it chose to. Okay, so Pennsylvania statute in this case imposed several distinct requirements, which we're going to talk about individually in just a second. But the case arrived at the Supreme Court amid very genuinely, widespread reported speculation that the court might use it to overrule Roe outright. All right, so that's the tension that you should kind of keep in mind as we're talking about Casey, because this was quite explicitly understood at the time as potential referendum on Roe's survival and not simply a routine abortion regulation case. All right, so let's brief the case. So first you have the facts, which is Pennsylvania imposed these 4 distinct requirements on abortion. You have informed consent, a waiting period, you have parental consent for minors, and then spousal notification, meaning that a married woman generally had to notify her husband before obtaining an abortion. The issue was, should Roe be overruled? And separately, are these specific Pennsylvania restrictions constitutional? Now, notice that Casey actually presents 2 distinct questions stacked together. So we have a question about precedent itself, and then a question about the specific regulations at issue. That structure matters because the court's answer to the 2 questions turn out to be different in an important way. Okay, so the holding was Roe's central holding was essentially reaffirmed. But the specific legal framework that was used to protect that right changed substantially. So the undue burden test replaced the the trimester framework, rather, not the first trimester, the trimester framework. And of Pennsylvania's 4 restrictions, that the specific restrictions, only the spousal notification requirement was actually struck down. Okay, so what does that tell you about the court's reasoning? That it reaffirmed Roe's central holding. It restructured the legal test almost entirely and then upheld 3 of the 4 specific state restrictions. Was that reaffirmation, was it a strong one or a weak one? And this was kind of the ambiguity that commentators across the political spectrum began kind of tossing back and forth. Okay, now this is worth sitting with for a moment because it's one of the more subtle and frequently misunderstood features of Casey. The joint opinion that was authored by Justices O'Connor and Kennedy and Souter it's an unusual grouping together itself, that's worth noting, but it explicitly preserved what it called Roe's central holding, that a woman has a constitutional right to choose to have an abortion before viability without undue interference from the state. But it discarded the trimester framework as the specific mechanism for protecting that right, replacing it with the single standard that's applicable throughout the pre-viability period, which was the undue burden test. Okay, and we're going to talk about that, so don't worry about that. So Casey is best understood as kind of doing 2 things simultaneously. So it reaffirmed the existence of the underlying right as a matter of stare decisis, while substantially rewriting the doctrinal test that was used to evaluate whether any specific regulation of that right is constitutional. So both halves of that statement matter, okay? And losing track of either one is going to cause you to misstate Casey's holding if you're ever having to use it on a practice or an exam or just talking about it with people. Now, one more structural point that is worth talking about before we move on. The joint opinion's unusual triple authorship, okay? O'Connor, Kennedy, and Souter all writing together rather than a single justice authoring for a majority is really doctrinally significant. It signals a coalition of justices who agreed on the outcome and the core reasoning, okay, but arrived there through somewhat different paths. A structure that later gives critics room to argue that the decision represents compromise as a much more clear, doctrinal conviction. All right, so keep that in mind when we reach Dobbs, since Dobbs is part of the majority's critique of Casey, which specifically targets the undue burden standard as unworkable and inconsistently applied by lower courts in the decades that follow. And that's a critique that some argue traces back to this very compromised, structure. Now, here is the new standard, okay? You have the law is unconstitutional if its purpose or effect is a substantial obstacle to a pre-viability abortion, okay? Now, notice the structure of that test carefully because both halves matter independently. So, a law is going to fail if either its purpose or its effect creates a substantial obstacle, meaning a law could be struck down even if lawmakers had entirely benign health related intentions, if the law's actual real world effect nonetheless creates a substantial obstacle. Okay, now conversely, a law with a genuinely improper purpose that's designed specifically to prevent women from obtaining abortions rather than to serve any legitimate regulatory interest could fail even if, in its practical effect, turned out to be relatively modest. Okay, so let's walk through the four Pennsylvania provisions and their outcomes, since this is exactly how the undue burden test gets applied in practice. All right, so we have informed consent, which was upheld. The state could require that a woman receive certain information about the procedure, about fetal development, and about alternatives before consenting, so long as that information requirement didn't function as a substantial obstacle. So, like a 24-hour waiting period, also upheld. The court finding that a delay of that length, while an inconvenience, doesn't rise to the level of a substantial obstacle for most women, even though the dissenting judges very, very sharply disputed that conclusion. Parental consent with a judicial bypass option for minors also upheld because the judicial bypass procedure gave minors who couldn't or wouldn't involve a parent an alternative path to obtain the required authorization. And then you have the spousal notification requirement, which struck down as an undue burden. So the court found that that requirement, unlike the other three, imposed a substantial obstacle specifically because of the realistic dynamics of some marriages, involving situations like with domestic violence, where requiring notification could expose a woman to a genuine risk of, violence or coercion or some sort, effectively preventing her from exercising the underlying right, even at all for a meaningful number of women. But let's look at this. You have three provisions upheld, one struck down. What does the distinguishing feature seem to be? What made spousal notification different in kind, not just in degree from the other three? Okay. The other three regulate process: informed consent, timing, and a judicial alternative for minors, where spousal notification could give a third party genuine practical power to prevent the decision entirely for at least some meaningful subset of women, which is a fundamentally different kind of interference with that underlying right. The undue burden test is genuinely one of the most important standards in this entire course to be able to state precisely, because it governed virtually all abortion, litigation in the United States for the 30 years between Casey and Dobbs. So every state regulation passed during that period was ultimately evaluated against this exact standard, the purpose or effect, the substantial obstacle, and the pre-viability. So this slide gives us a direct quote from the joint opinion, and I want to read it to you slowly because the reasoning here is doing something distinct from anything that we've discussed so far today. And it's not really about the merits of the underlying right at all. It's about the doctrine of stare decisis itself. And the quote is, "An entire generation has come of age free to assume Roe's concept of liberty in defining the capacity of women to act in society." This is a reliance interest argument, and it is worth understanding as its own distinct category of constitutional reasoning, separate from asking whether Roe was correctly decided on the merits in 1973. The joint opinions arguments run roughly as follows. Even if reasonable people could disagree about whether Roe was correctly decided as an original matter, an entire generation of Americans had structured their lives, their expectations, and their social and economic participation around the assumption that this right existed. Overruling it nearly 2 decades later, the joint opinion argued, would inflict a distinct kind of harm, disrupting settled reliance above and beyond any disagreement about the original correctness of the decision. So that's worth connecting directly to the general stare decisis doctrine, which you've encountered, elsewhere in this semester. But courts generally give precedent extra weight, simply, actually beyond simply asking whether the precedent was correctly decided, because stability, predictability, and reliance have independent value in a legal system. So Casey's joint opinion is applying that general principle specifically and forcefully to Roe. So, whether that reliance based argument for retaining Roe was ultimately persuasive is precisely the question that Dobbs Court would revisit 30 years later, and we'll see very shortly was answered very differently. All right, so let's consolidate the differences between the two cases using this comparison table. And that way you'll be able to see the differences very plainly. And with framework, Roe has the trimester stages, a calendar-based three-part structure. Casey replaced it with a single viability line, pre-viability versus post-viability, with that undue burden test applying uniformly throughout the entire pre-viability period rather than varying by like which trimester a woman happened to be in. Okay. The standard Roe applied a very strict scrutiny to the first trimester regulations, a demand that the standard basically requiring the state to show that compelling interest and narrow tailoring. So Casey replaced it with the undue burden test, which is a standard that many scholars and justices at the time described as meaningfully less protective of the underlying right than strict scrutiny would have been, since it permits, more regulation to survive so long as it doesn't rise to the level of a substantial obstacle. Then you have the deferences to the state. So Roe afforded the states minimal deference, particularly in the first trimester, where state regulation was essentially, foreclosed entirely. Casey afforded states meaningfully greater deference throughout the pre-viability period, upholding three of the four, Pennsylvania provisions that we talked about, that likely would not have, survived under Roe's strict, first trimester rule. Now, given this comparison, would you characterize Casey as narrowing the right that Roe created, expanding it, or something entirely? Your mileage may vary, but I see it as Casey narrowed the level of protection the right received, even while formally, reaffirming that the underlying right continued to exist. So both things are simultaneously true. Okay. And a precise answer basically needs to hold both, right? But this comparison, it's going to matter enormously for understanding Dobbs, which we're about to reach, because Dobbs didn't simply pick a side between Roe's approach and Casey's approach. It rejected the entire premise that either case had gotten right, and that was the existence of a federal constitutional right to abortion in the first place. Now we're at the turning point. We're at Mississippi's Gestational Age Act, which banned abortion after 15 weeks, and it directly invited the court to revisit Roe and Casey. Okay? Now, I want you to notice something important about how this case reached the court. All right? You have a 15-week ban, and that is flatly inconsistent with both Roe's trimester framework and Casey's viability line. 15 weeks falls well before the roughly 24-week viability mark that both prior frameworks, treated as the regulatory threshold. Okay? So Mississippi's law wasn't crafted to survive under existing doctrine. It was crafted specifically to force the court to choose between striking down the law under existing precedent or to use the case as a means to reconsider that precedent altogether. Okay? So we have our three-step arc here in a single clean timeline. We have Roe 1973, the rights recognized. We have Casey 1992. The right is narrowed, but reaffirmed. And then we have Dobbs, 2022. The right's overruled, and the entire question of abortion regulation is returned to the states. Now, based on everything that we've talked about when it comes to stare decisis and Casey, okay, what do you think the Dobbs majority would have needed to say, doctrinally speaking, in order to justify overruling a precedent that had itself been explicitly reaffirmed on stare decisis grounds just 30 years earlier? Okay? And it's not something. Basically, there's this whole debate, right? The Dobbs majority concluded that Roe was egregiously wrong from the moment that it was decided, and that the reliance interest that Casey emphasized was not the kind of concrete workable reliance that stare decisis is meant to protect. Now, I want to be precise about exactly what Dobbs held. All right, because this gets oversimplified constantly in public discussion. Dobbs did not make abortion illegal nationwide, and it did not hold that states must ban abortion. Dobbs held that the Constitution does not confer a right to abortion. The authority to regulate abortion is returned to the people and their elected representatives, meaning individual state legislatures, and in some states, direct ballot initiatives. All right? The practical effect was that abortion law in the United States, which had operated under some like uniform federal constitutional floor for nearly 50 years, became a matter of state by state variation, ranging from full protection to near total prohibition. All right, depending entirely on the state's own legislative and political choices. All right, so keep this three case arc in mind. All right, widely recognized 1973, narrowed but reaffirmed 92, overruled entirely in 2022. Okay, because we're going to leave abortion doctrine behind and we're going to switch over to the right to refuse medical treatment and the question of physician assisted death. Okay. But I do want to say, because I do believe that it matters for understanding the court's composition and how it shapes doctrine over time. Dobbs was decided by a majority of the justices sitting on the court in 2022, with dissenting judges arguing forcefully that the majority had abandoned settled reliance, interest, and stare decisis principles. The Casey joint opinion had specifically emphasized all of this 30 years earlier. And that dissent is worth reading in full if you want a genuinely rigorous take of stare decisis and its arguments that we've discussed. it's now been, directly applied to the specific choice to overrule Roe and Casey rather than reaffirm, a second time. All right, so now we have to shift to a new doctrinal thread, but it is built on the same medical autonomy concept that we've defined earlier today, which is about bodily integrity, informed consent, and freedom from unwanted, medical treatment. And it's the right to refuse medical treatment. This is a genuinely distinct question from abortion, even though they arise from the same underlying due process liberty interest. So, abortion asks whether the Constitution protects the decision to end a pregnancy. The next case or the next line of cases actually, is going to ask whether the Constitution protects the decision to refuse medical care, even care that would keep a patient alive. Okay. And we have three concepts that anchor this thread. And I want you to notice how they echo that medical autonomy framework from abortion. Informed consent, just the right to know about the proposed treatment and to decline it. Bodily integrity, the freedom from unwanted treatment being imposed on you. And then medical autonomy, broadly, it's just control over one's own care. Again, this umbrella concept that sits under both areas. We have things like if a patient has a right to refuse medical treatment, even life-sustaining treatment, does that automatically mean the patient has the right to affirmatively end their own life with medical assistance? Are those the same question or are they different ones? And the thing is, we can't necessarily resolve this. We're going to talk about it as we're going through. And the court's answer, as we'll see, is that these are two genuinely distinct questions with two genuinely distinct constitutional answers. All right, so this case involves genuinely difficult facts, and I want to walk through them carefully and respectfully since they involve a real young woman and her family. So you have Nancy Cruzen, and she is the patient at the center of the case, and she was left in a persistent vegetative state following a car accident, okay? She showed no cognitive function and she had no reasonable prospect of recovery. All right. Her family wanted to have her feeding tube removed, believing that continuing artificial nutrition and hydration was not what she would have wanted for herself, based on statements that she had made to family members before the accident. So the issue was, does the Constitution protect a right to refuse medical treatment? And the holding in this case was that yes, for competent patients, then the Constitution is going to protect a liberty interest in refusing unwanted medical treatment, including life-sustaining treatment, okay? But for incompetent patients, patients like Nancy, who can no longer express their own wishes, the court held that states may require clear and convincing evidence of what the patient's own wishes actually were before family members or others can direct the withdrawal of the treatment on the patient's behalf. Okay. And think about this, like why might a state want a heightened evidentiary standard, which is a clear and convincing evidence, which again is higher than your, simple preponderance of evidence, specifically for decisions about withdrawing life-sustaining treatment from someone who can no longer speak for themselves. And ultimately, it's about the irreversibility of the decision. Unlike most civil disputes, a wrongly decided case here cannot later be corrected, which the court found justified in using a higher burden of proof than ordinary civil litigation typically requires. Okay, Cruzen is the first right to die case to recognize a liberty interest under the Due Process Clause, and it's our first explicit doctrinal confirmation that the same substantive due process framework that we've used all day for reproductive autonomy also extends, at least in some form, to the end of life medical decision making. Okay, so I want to draw out like a structural feature of this holding that matters enormously for everything that follows today. Cruzen protects a right to refuse treatment, meaning a right to decline something being done to you. All right, it does not establish any right to demand a particular treatment. And as we'll see later in this lecture, It does not establish any right to effective or not effective affirmative assistance in ending one's life. Okay, so the court was careful to frame this as a right that's grounded in common law tradition of informed consent and the corresponding right to refuse it, which is a well-established doctrinal, lineage, rather than announcing some more broad freestanding right to control the timing and the manner of one's own death. Okay, so the clear and convincing evidence standard that the court upheld, this also deserves a moment of its own attention because it created a real practical consequences that echo directly into our next case. And in the absence of a written advance directive or sufficiently clear prior statements, then family members could find themselves unable to meet this heightened, evidentiary burden, even when they were genuinely confident about what their loved one would have wanted. And that's the exact gap, which is the clear, the absence of clear documentation, is the situation at the center of the Terry Schiavo case, which we're going to talk about, next. Um, it is worth noting the eventual outcome, though, briefly and respectfully here. After the Supreme Court's decision, Nancy Cruzen's family, they went back to Missouri State Court with additional witnesses who testified to the statements that she had made about her wishes. And the state court found that the additional evidence satisfied that clear and convincing standard, and her feeding tube was ultimately removed. But this this matters. It shows that the Cruzen, it didn't categorically bar families from meeting this heightened evidentiary standard. It just simply required them to actually produce the sufficient evidence, which in that instance, the family was actually able to do. All right, so now we're going to apply the Cruzen framework to a real world case. Some of you may remember this, and it's probably the most actually publicly followed right to die controversy in American history. But let's walk through the elements as we are doing this. We're going to talk about Terry Schiavo. So we have the persistent vegetative state. So Terry collapsed in 1990 and suffered a cardiac arrest that caused severe brain damage and left her without cognitive function for many years to come. Advanced directive. So Terry Schiavo had no written directive, no living will, no healthcare power of attorney, nothing in writing specifying what she would have wanted in this exact situation. So this absence is the single fact that turned a private family and medical decision into a very long 15-year legal battle. Then we have a family conflict. So we have her husband, who had been appointed her legal guardian, and he believed that she would not have been wanted to stay alive in that condition. And he fought to have her feeding tube removed, where her parents disagreed and they believed that recovery was still possible and that she would have wanted to continue receiving, nutrition and hydration. That's exactly the kind of dispute that the Cruzen's clear and convincing evidence standard was designed to resolve. But in that same vein, it's also exactly the kind of dispute where, without any kind of written documentation, that standard becomes genuinely difficult to satisfy either way. Okay? So then we have our legislative and judicial response. So between 2003 and 2005, the case moved through Florida state courts multiple times, and it prompted special legislative intervention in Florida, sometimes called Terry's Law, and eventually prompted an extraordinary act of federal legislation. It was passed specifically to allow the case to be reviewed once more in federal court. Now, all of those interventions were ultimately unsuccessful in changing the underlying judicial determination. And honestly, the case to this day remains probably the most extensively litigated and legislated end of life cases in American history. And what does that tell you about our legal system? That a private family's medical decision became the subject of state legislation, a special act of Congress, and a repeated federal court review. Okay? And there's no right answer to this. I mean, there's genuinely multiple reasonable perspectives there. You've got concern about like protecting vulnerable patients versus, concern about government and political intrusion into something that is deeply personal when it comes to family and medical decisions, right? But I do want to draw a a doctrinal thread explicitly here because it's the actual point of studying this case in a constitutional law course rather than as a simple like family tragedy, like actually human tragedy more than anything else. Chavo is best understood as Cruzen's clear and convincing evidence standard playing out in the hardest possible, real world circumstances. You have a patient with no written directive. You have a family in genuine, sincere disagreement, and then you have a legal system that is straining to determine after the fact what a person who can no longer speak for herself would actually have wanted. All right. So the case's most practical, like direct lesson, and what we're going to continue to kind of build on is almost painfully simple to state, but also remarkably difficult for most people to actually act on. Put your wishes in writing while you still can, so the people that you love are never forced into that position, period. All right, I'll get off my soapbox. Now, what happens when medical decision-making authority belongs, in the first instance, to a parent making choices on behalf of a child, and that parent's choice is in conflict with what the state believes is in the child's medical interest? Okay, so this slide gives us four connected concepts. First, we have parens patri, and it's our foundational doctrine. Okay, it's the state's inherent power to protect the welfare of the children and other individuals who cannot fully protect themselves. All right, this is a very old doctrine with roots stretching all the way back to the English common law. And it operates as a kind of background check on parental authority in situations involving risk to a child's welfare. Then you have Prince versus Massachusetts, and that established a key limiting principle for our purposes today, which is parental rights, including rights grounded in religious belief, are not absolute. Okay, so the state retains authority to intervene when a child's welfare is genuinely at stake, even against a parent's sincere religious or personal objections. Okay. Then we have blood transfusion cases, and these are kind of the paradigm example in this specific area, where situations where a parent's like sincere religious objection to a medical procedure, most commonly blood transfusions, are in conflict with a physician's determination that a procedure is medically necessary to save and or protect the child's, life or the health. Okay. And I know you're probably thinking, how is this, parents' patry line of cases different from Cruzen and Chavo? Like, whose autonomy is actually being weighed against whose interest here, right? Cruzen and Chavo involve adults' own, and their medical autonomy, exercised either directly through documented or inferred wishes prior to, right? The parents' patry cases, those involve a child who cannot yet exercise autonomous medical decision making at all, and a state's interest in protecting that child's welfare that exists independently and can sometimes override a parent's own decision making authority. And medical neglect. It's the final concept here. This is where courts can override a parent's refusal of medically necessary treatment for a child in appropriate circumstances, precisely because the underlying decision-making authority in these cases ultimately belongs to the state acting to protect the child, not solely to the parent. This does not mean that parental authority over a child's medical care is like illusory or anything like that. But in like the vast overwhelming majority of cases, parents retain full decision-making authority, and courts intervene only in genuinely serious situations involving real risk to the child's life or health. Okay. But for today, we're going to focus on the fact that this authority has limits, and Prince versus Massachusetts is the case that establishes that it exists. Okay, but this slide, it is a useful reminder that medical autonomy doctrine, it's not a single uniform rule that's applied identically to every person in every situation. It varies significantly depending on who is making the decision and on whose behalf and what kind of underlying interest exists. An adult's own bodily autonomy, a family member's substituted judgment for like an incapacitated adult, or a state's protective interest in a child's welfare. What's actually at stake in the specific case? Now, this right here gives us some practical document-based tools that exist specifically to prevent the kind of prolonged legal battle that happened in the Chavo case, okay? Um, and because these exact tools are the kinds of documents that you would be um, working with in estate planning or healthcare practice, I want to kind of talk about them a little bit more. So, like a living will is a written document that contains specific treatment instructions. It's going to state, like in advance, what medical interventions a person does or does not want under specified future circumstances, most commonly your end of life circumstances involving terminal illness or permanent unconsciousness. A healthcare power of attorney is going to designate a specific decision maker. And it's sometimes called a healthcare proxy or a healthcare agent. And it is somebody who is legally authorized to make medical decisions on the person's behalf if they are unable to make those decisions themselves. Okay, notice that that differs from a living will. The living will states specific instructions in advance, while a healthcare power of attorney is going to designate a person that is a trusted person. To make judgment calls in real time, informed by whatever specific circumstances are actually coming up, which the original document, can't possibly anticipate in full detail. Substituted judgment is the legal standard that many states apply when a decision maker, whether a healthcare agent or a family member, has to decide on behalf of an incapacitated patient without a specific written instruction covering the exact situation at hand. So, under substituted judgment, the decision maker is asked to decide as the patient would have decided based on the patient's known values, any prior statements, and the general approach to life, not simply what the decision maker personally believes would be best. And then we have clear and convincing evidence, which we already, talked about in Cruisin'. But it's the heightened proof standard that many states require before life-sustaining treatment can be withdrawn from an incapacitated patient who has left no written directive. Exactly the evidentiary gap that the Chavo case made so difficult and prolonged. But I mean, given everything that we've talked about with Cruisin' and Chavo, think about which of those tools would have been most useful for Terry Chavo to have had in place. Would it have been the living will? And I personally think it would have been, because it most directly would have supplied a clear written evidence of her actual wishes. That litigation spent over a decade trying and ultimately unsuccessfully concluding in any kind of legal form to establish, through any other means. But from a practice perspective, this slide is genuinely one of the most directly useful, I think, in today's lecture. Again, advanced directive drafting, it's common, it's recurring work in estate planning practices, in healthcare, and you're frequently going to help clients understand those documents to gather the information that's needed for them, to complete them accurately and to ensure that they are, properly executed under the specific formality requirements of the state. So understanding why these documents matter and not just how to like fill out the form, but the exact like legal gaps they're designed to close, I think helps make you, genuinely a more capable member of a practice team. Now let's talk about a question that we deliberately left open, and that is, does a right to refuse treatment imply a broader right to affirmative assistance to end one's life? Glucksberg gives us the court's answer. And I want to walk through the reasoning carefully because the methods matter just as much as the conclusion. Okay, so the facts of the case, this is physician-assisted suicide, I should say. Washington State had a law that was criminalizing assisting a suicide. So terminally ill patients and physicians who wished to participate in physician-assisted death sued, arguing that the law violated a constitutional right. All right, so the issue before the court was, is there a fundamental right to physician-assisted suicide? And the court held no. It said that such a right is not deeply rooted in this nation's history and tradition, and that Washington laws survive under rational basis review, a far more deferential standard than the heightened scrutiny that would apply if the court had recognized a fundamental right. Okay, so we've spent like the past, I don't know, 90 minutes or so, however long it's been, studying Casey and Roe and Dobbs and Cruzen. And based on the whole entire arc, what test do you think the Glucksberg court used to decide whether this was a fundamental right in the first place? You know, I'm going to go with that whole deeply rooted in history and tradition test, which is a flag for you, by the way, because it's the same historical inquiry method that the Dobbs majority would later apply to abortion, 25 years after. So Glucksberg is, in a real sense, kind of the template that Dobbs would eventually use. But I digress. Glucksberg case asked whether the asserted right, physician-assisted suicide, was objectively deeply rooted in the nation's history and legal traditions. And they found that it was not, noting that the vast majority of states had long criminalized assisting suicide with no significant historical tradition supporting a contrary right. So the court declined to recognize it as fundamental. All right, that same historical rootedness inquiry applied to a different asserted right is precisely, again, the analytical method that the Dobbs majority used, a quarter century later to conclude that abortion was not, in fact, a deeply rooted, in the nation's history and tradition either. Okay. So here's something for you to take away. Glucksberg represents one identifiable strand of substantive due process methodology. It is a cautious, historically anchored approach that's reluctant to recognize new fundamental rights that are not clearly grounded in long-standing tradition. Roe and Casey, they represent a different strand, one that's more willing to extend existing, precedent incrementally to these new circumstances, like as we saw with Meyer and Pierce and Skinner and Griswold and Eisenstadt, the whole line that was building toward Roe. All right, so watching those two, strands kind of coexist, and eventually watching the historically anchored strand become dominant in Dobbs is genuinely like the intellectual core of everything we've kind of covered today. So significance plainly stated, Glucksberg established that there is no fundamental right to a physician's assisted suicide under the federal constitution. States are going to remain free to criminalize it, and Washington did. And importantly, states are also free to legalize and regulate physician-assisted suicide if their own legislatures choose to do so, which a number of them have done, since through their own statutes. But Glucksberg sets the federal constitutional floor. So it's not preventing the states from providing greater protection through their own state law. That's just kind of a pattern that should feel familiar, though, from our Dobbs discussion, where the regulation authority is likewise simply returned to the states. Now, decided on the very same day as Glucksberg, this companion case approaches the same underlying subject from a completely different constitutional angle, and it's not due process, but equal protection. Okay, so we have a New York law that allowed patients to refuse life-sustaining treatment consistent with Cruzen, but banned physician-assisted suicide consistent with the position that Washington took with Glucksberg. So patients challenged this distinction, arguing that treating these two situations differently violated the Equal Protection Clause, since they argued both situations ultimately end in the patient's death through choices made with medical involvement. All right. The issue before the court was, does this legal distinction, permitting one path to death but not the other, violate equal protection? And the holding was no. And the court said that the distinction between letting a patient die by honoring a refusal of treatment and actively assisting a death through the provision of lethal medication is rational and therefore survives equal protection under a deferential rational basis standard. Okay, so what's the court's actual reasoning for these two scenarios that are meaningfully different rather than just two paths to the same outcome, right? Causation, intent. In a refusal of treatment case, the underlying disease or the cause or the condition causes the death. And the intent is to avoid unwanted bodily invasion. In assisted suicide, a lethal medication causes the death, and the intent is specifically to end the life. So the court treated that distinction in both the causal chain and the underlying intent as legally meaningful and not merely like a semantic difference that was dressed up to avoid like a harder constitutional question, if that makes sense. Um, and pairing directly with Glucksberg decided the same day, because together they form a genuinely coordinated doctrinal position. They approach those two different constitutional angles. Glucksberg says, look, there's no freestanding due process right to assisted suicide. Bacco says treating assisted suicide differently from treatment refusal doesn't violate equal protection either because two things are legitimately rationally distinguishable. So two different constitutional theories tested on the same day, on the same underlying policy question, reaching the same practical result on that very same day. It's a good illustration of a broader lawyering lesson that's kind of worth talking about explicitly. When a single constitutional theory doesn't succeed, litigants often try a second, structurally different theory on the very same facts. And here, the same underlying advocates and interests pursued both a due process theory and an equal protection theory, simultaneously in companion cases, precisely because these are analytically distinct constitutional doctrines even when they're being deployed to the same, practical goal. Now let's kind of consolidate everything. Cruzen, Glucksberg, Bacco, let's talk about some distinctions, okay? Legal status, refusing treatment is a recognized constitutional right, which was established in Cruzen. Assisted suicide carries no fundamental right as established in Glucksberg. Cause of death, in treatment refusal cases, the underlying condition itself causes death. In assisted suicide, a lethal medication administered or provided with medical assistance causes death. Intent, in refusing treatment, the patient's intent is toward unwanted medical intervention. In assisted suicide, the intent is specifically to end their life. And then recognized in Cruzen 1990 for the right to refuse treatment, Glucksberg 1997 for the rejection of any fundamental right to assisted suicide. So if a state legislature wanted to legalize physician-assisted death within its own borders, again, as a number of states has done, would Glucksberg stop it from doing so? No. Glucksberg holds only that federal constitutions, or the federal constitution does not require states to permit assisted suicide. It says nothing about a state from choosing to permit and regulate it through its own state law, which is exactly the same federalism structure that we saw in Dobbs, returning abortion to the states. And this three-case comparison, Cruzen, Glucksberg, Bacco, it's the clearest illustration of how the Supreme Court draws carefully, sometimes fairly technical lines within what might look to a layperson like single, undifferentiated questions like the right to die. Okay, but the law, as we see in detail, actually recognizes several distinct sub-questions, each within its own doctrine, in its own history, and even in its own answer. Now this slide here, it gives us a deceptively simple visual. We have liberty, then privacy, and then medical autonomy. And it's connected by arrows, but I want to unpack that progression and what it's actually claiming, because the backbone running underneath everything we've covered today is worth talking about just a little bit more. And liberty, it's the broadest constitutional concept. The word actually appearing in the Due Process Clause of the 14th Amendment itself. Privacy is a specific, judicially developed subset of that broader liberty concept that's built case by case, as we have continued tracing at the very start, from Meyer all the way through. And medical autonomy is a further specific application of that privacy doctrine that's extended to decisions about one's own body, their health, and ultimately questions surrounding the end of life. So every single case that we've talked about today, Roe, Casey, Dobbs, Cruzen, Glucksberg, Baco, Chavo, I feel like I'm missing some. They can all be understood as the court either extending or declining to extend that same liberty to privacy to medical autonomy chain to a new specific factual context. So Roe extended to the abortion decision. Casey narrowed but preserved that extension. Dobbs eliminated it as a matter of federal constitutional law entirely. All right, Cruzen extended the chain to the right to refuse treatment. Glucksberg and Vaco declined to extend it further to the right to assisted death. Okay, so understanding this as a single connected chain rather than 6 disconnected cases to memorize like independently, is what's going to separate you when it comes to your understanding, having a stronger understanding from merely adequate understanding, it's doctrinal literacy. It's going to let you help to explain clearly and precisely why the law treats these questions so differently without needing to take on any personal position on the underlying policy debates at all. Again, you don't have to agree with it to understand it. All right, so now let's talk finally about these 2 competing interpretive philosophies. And it's because they explain why the court's approach to the unenumerated rights shifted so dramatically across the cases we talked about today. So I just want to present both kind of fairly and rigorously because both do represent serious, long established traditions of constitutional interpretation held by thoughtful, jurists and scholars across the political spectrum. Now, originalism holds that constitutional provisions should be interpreted according to their meaning at the time of ratification. So, under that approach, rights that are not grounded in the Constitution's text, structure, or history, rights not deeply rooted in the nation's tradition, belong to the political process. So, the legislatures and voters, not the courts. Um, you know, as this slide notes explicitly, Dobbs applied that approach, conducting exactly the kind of historical inquiry into the nation's, traditions regarding abortion regulation that an originalist methodology calls for. So the living constitution approach, which is sometimes also called constitutional pragmatism or evolving meaning interpretation, there's a few others too, but they hold that constitutional meaning can evolve as society's understanding of liberty, equality, and human dignity develops over time. So under that approach, the rights can grow to meet new circumstances that the Constitution's framers may not have specifically anticipated. All right. And as you see, it notes that Roe and Casey reflected that approach, building an abortion right incrementally from the privacy precedents that themselves developed gradually, over decades in response to evolving social understanding. So I don't know if you can identify specifically like one argument in favor of each approach and serious critique, but the thing of it is that it can help you to explain positions to someone who doesn't hold either view really. Um, like let's work through a version of this, okay, just so that it kind of makes sense. So in favor of originalism, all right. It constrains judicial discretion. It arguably increases predictability and legitimacy, also by tying constitutional meaning to a fixed knowable historical reference point, and it keeps genuinely contested moral and social questions in the hands of the elected, politically accountable legislatures rather than the unelected judges. Okay, so a serious critique of originalism. Um, you have historical inquiry into what is considered deeply rooted in tradition, and that in and of itself can be contested and selectively framed. And some argue that it risks freezing, constitutional protections at the moral and social assumptions of a much earlier and less inclusive era. Okay. Now, in favor of living constitution approach, it allows, constitutional protections to keep pace with the evolving social understanding. And its defenders argue it better serves the Constitution's broad and enduring principles, liberty, equality, dignity, rather than freezing like their application to circumstances that the framers could not have begun to anticipate. Okay. But a serious critique of that approach is that critics argue, it risks substituting judges' own contemporary, policy preferences for the actual text and structure of the Constitution, and that it can make the constitutional meaning feel unpredictable and dependent on which judges happen to be sitting on the bench at a given moment in time. Okay. Now I want to be genuinely clear about something before we move on. This course is not asking you to adopt either of these philosophies as your own, just FYI. It's just asking you to be able to explain both with equal fluency and equal fairness. Okay, because as a legal professional, you're going to work with people and you're going to need accurately you're going to need to be able to accurately understand and represent, arguments that are grounded in these interpretive philosophies, whether or not you actually hold them. Now, we have three genuinely open questions that scholars, judges, and commentators continue to debate, and I want to present all three as live contested questions because that's exactly what they are, not questions with a single answer that this course is going to hand you. First up is judicial activism. Are judges creating unlisted rights that don't actually belong in the Constitution's text? Are they effectively legislating from the bench? That critique has historically been leveled most often at decisions like Roe, but it is worth noting for its intellectual honesty that critics have been able to level, a structurally similar charge, judges substituting their own preferences for constitutional text. And they did that with Dobbs as well, from the opposite direction and against a range of other cases that are entirely unrelated to today's topic at all. But it's a recurring critique in constitutional law, generally speaking, not confined to just abortion or right to die doctrines, specifically. Federalism. Should states and voters decide these questions instead of federal courts? And that's precisely the structural shift that Dobbs itself accomplished, when it returned abortion regulation to the state legislatures. And in some states, it was also returned to the direct ballot initiatives. But proponents of that shift argue it better respects democratic self-governance and allows different states to reflect the differing values and preferences of their own populations. So critics of the same shift, though, they argue that fundamental rights shouldn't depend on which state a person happens to live in. Which brings us directly to the third question, and that's individual rights and geographic inequality. Does returning these questions to the states leave liberty unequal by geography? Meaning a person's practical legal rights and options now depend substantially on which state they happen to reside in. This, again, is a genuinely contested question. So some view state by state variations as a healthy, expected feature of federalism, allowing, local democratic self-governance on contested moral questions. Others see it as troubling outcomes for what they see as fundamental, individual rights, which they argue should not vary by state line. And look, let's take these one at a time. I mean, what's the strongest version of the argument in favor of returning these decisions to the state? And in the alternative, what's the strongest version of the argument against doing so? You have the ability to state both positions as persuasively and fairly as possible. You don't have to declare a personal winner. Just you have to be able to learn to demonstrate a genuine command of arguing, and that's the kind of skill that is where you're going to see effective advocacy and neutral, legal analysis, and that's where you're going to be the strongest. Um, in all honesty, we've deliberately not resolved a lot of those questions, and that's intentional, not an oversight. And that's because they are genuinely unresolved, actively debated questions in American law and politics. And a constitutional law class does you a disservice if it pretends otherwise in either direction. So it's I'm here for I'm here to teach you how to see both sides. Remember I told you we have a moral compass, we have a political compass. A lot of times those line up together. We also have a legal compass, and that's where we have to learn to operate. Again, we don't have to agree with the law to understand it. Now, because of everything we've covered today has genuine immediate relevance to legal work that's happening all over right now, let's talk about some areas that you might work in. So, like healthcare. We talked about doctrine that directly shapes, medical decision-making frameworks used by hospitals, physicians, and healthcare systems every single day. We're talking informed consent procedures, refusal of treatment, protocols, and the legal weight that's given to these advanced directives and whatnot, and they all trace back to the cases we talked about. Family law, today's material connects directly to parenting and guardian disputes, and we're talking about situations where medical decision-making authority for a child or an incapacitated family member becomes contested. Echoing the parents' patry doctrine that we talked about as well. You've got hospital practice where it's consent procedures and end-of-life protocols in virtually every single hospital built. In significant part around this cruising framework in the advanced directive that we talked about, you got living wills, healthcare power of attorney, substitute judgment standards, all coming from this. And then we have future legal issues, because this area continues to actively develop. We have emerging questions that include like how these frameworks apply to new reproductive technologies, how the state by state variations on both abortion laws and assisted suicide laws are going to continue to evolve after Dobbs and other cases. How courts will continue to refine the line between constitutionally protected autonomy and legitimate state regulatory interests. And this is all genuinely new factual context that we haven't even begun to fathom yet. Now, as we close today, let's look ahead to the next one, and that is the Equal Protection Clause of the 14th Amendment, moving from liberty to equality. And we're going to talk about how race and the birth of strict scrutiny shaped equal protection doctrines and formally defined the three levels of scrutiny. We have strict scrutiny, intermediate scrutiny, and rational basis review. Terms that we've already talked about a little bit today in Glucksberg and Vaco's use of rational basis review, and Roe's use of strict scrutiny for the first trimester regulations. But next week, we are going to talk about Brown and Loving and Craig and a whole bunch of others in terms of modern equal protection, and we're going to discuss it more broadly. So if today felt like a kind of a deep sustained study with substantive due process, liberty, and personal autonomy, next week kind of shifts to a structurally related but analytically distinct constitutional inquiry. And it's not what liberties the government must respect, but when the government's classification and distinctions between groups of people violate the constitutional guarantee of equal treatment under the law. And that's pretty much it. Thank you guys for obliging me. I know that, again, this is a really difficult one because it is one that is emotionally charged. So I thank you for that. But I will see you guys next time. Bye.